No, there's a battle brewing, not in the headlines, but buried deep in a 1,000-page budget bill moving through the House. A single paragraph could quietly strip federal judges of their ability to enforce certain rulings. Legal scholars say it targets the very power courts rely on to hold the government accountable. Here's legal scholar Dr. Brian Marks to talk about it. Are we looking at a violation of Article 3 under the United States Constitution in that the circumscription of the judicial power to enforce contempt amounts to basically unconstitutional acts? And it could be read through the lens of potentially a counter-majorian argument where the judiciary is unelected, and therefore, if Congress decides that it is fair to limit contempt to some extent, or the enforcement of contempt, that's reasonable, because otherwise we're questioning the democratic process.
In 1803, in the case of Marbury versus Madison, it became clear the role of the Supreme Court and, quite frankly, the judiciary in interpreting constitutionality of statutes and the application of the Constitution. Our whole constitutional design, it is structured to provide for three branches. The framers knew from the start the judiciary were going to be appointed. So that's a recognition of the role of the judiciary throughout.
You could look at this through the lens of even the Federalist Papers, say Federalist Paper number 78, in which the executive has to acquiesce to judicial power, and that if the Trump administration is not acquiescing to judicial power in the form of selectively complying with some of these court orders, maybe it is defining a new era of constitutional minimalism and executive maximalism. Have we arrived there? Are we heading in that direction?
So I'm going to take issue with your notion of constitutional minimalism. You know, we have a Constitution of the United States. It clearly defines the powers of each branch. We can look at the Federalist Papers, but however, the 1803 decision and subsequent decisions from the Supreme Court made the Supreme Court the arbiter of disputes with respect to cases and controversies with respect to constitutional matters. I do not think at the end of the day, when people look, that people would view, although there are some who believe in the unitary executive, I don't think that's the frame in which our founders constructed our constitutional framework.
Could skeptics and those who are opponents of the president look to United States v. Klein from 1872 and say that there is precedent that's established there because the Supreme Court decided that Congress wasn't able to tell the courts how they should interpret presidential pardons, and that that was an imposition or an encroachment on judicial authority?
There is no doubt that we can look through the history and tradition of our country and point to various aspects. The president's authority, and I may be in the minority here, is not unfettered. We have learned, at least from a criminal perspective, there's immunity. There's the notion of impeachment. That is an enforcement mechanism that Congress can implement. We are in a time in which we have an administration challenging not only the laws, but many social norms and constitutional norms and norms of practice. And I'm okay with questioning. I'm okay with challenging. I think those are all healthy things to do for a constitutional democratic republic like the one we have. But the core premise is that there needs to be constraints.
And this proposal hasn't passed yet and, of course, faces major hurdles.